In 2015, two brothers from Houston launched a commercial cleaning company with a single contract and a secondhand van. By 2021, that company had grown to $12 million in annual revenue, 147 employees, and contracts with some of the largest commercial real estate firms in Texas. Then one of them signed a document. Not a fraudulent document, not a forged document, a legitimate legal agreement that he had the full authority to sign. Within 18 months of that signature, the company was in receivership. The contracts were gone, the employees were laid off, and the two brothers were in civil litigation against each other. This is the full account of what that document was, what it committed the company to, and why neither brother fully understood what they were agreeing to until it was too late. The company, we will call it Apex Commercial Services, was founded by brothers Leon and Curtis in 2015. Leon handled operations. Curtis handled sales and client relationships. The division of responsibility was informal but consistent. It had worked for 6 years. By 2020, the company was generating $8 million annually and had attracted the attention of a private equity firm looking to consolidate commercial cleaning operations across the Southwest. The private equity firm approached Curtis directly. They were interested in a partnership, not an acquisition. A growth investment in exchange for a minority equity stake and a seat on an advisory board. Curtis was interested. Leon had reservations. The conversations went on for 4 months. In January 2021, Curtis signed a letter of intent with a private equity firm. A letter of intent, commonly called an LOI, is a document that outlines the preliminary terms of a proposed agreement. It is typically described as non-binding, and in most of its provisions, it is. But buried in the LOI that Curtis signed was an exclusivity clause. That clause stated that Apex Commercial Services agreed not to enter into discussions with any other investor, acquirer, or financial partner for a period of 180 days from the date of signing. Curtis signed it believing the LOI was a starting point, an expression of mutual interest, not a commitment. Leon did not know the LOI had been signed until 3 weeks later. What happened over the following 180 days defined everything that came after. The private equity firm used the exclusivity window to conduct due diligence. During that process, they identified 3 issues with Apex's financial records: inconsistencies in how contract revenue was recognized, underfunded worker compensation reserves, and a client concentration risk where one client represented 34% of total revenue. None of these issues were fraudulent. They were accounting and structural weaknesses common in fast-growing small businesses that had not yet formalized their financial operations. But to the private equity firm, they represented risk that required renegotiation of terms. They came back with a revised offer. The equity stake they wanted increased from 25% to 40%. The valuation they assigned to the company dropped by $2.1 million. And they added a performance clause that would allow them to increase their stake further if the company missed revenue targets in the first 2 years. Curtis wanted to negotiate. Leon wanted to walk away and find a different investor. They could not walk away. The exclusivity clause Curtis had signed prevented them from approaching any other investor for the remaining 90 days of the exclusivity window. They were negotiating from a position with no alternatives. They rejected the revised offer. The private equity firm responded by invoking a provision in the LOI that Curtis had not focused on during signing, a cost recovery clause that required Apex to reimburse the firm for due diligence expenses if the deal did not close. Those expenses totaled $187,000. Apex contested the clause. Their attorney argued it was unenforceable given the circumstances of the renegotiation. The private equity firm's legal team disagreed and filed suit. The litigation lasted 14 months. During that period, the uncertainty surrounding the company's ownership and financial position became known to 2 of Apex's largest clients. Both declined to renew their contracts, citing concerns about stability. The client that represented 34% of revenue was one of them. The company lost $4.8 million in contracted annual revenue within a 6-month period while simultaneously managing active litigation. They could not sustain both. In March 2023, Apex Commercial Services entered voluntary receivership. The receivership process placed the company's assets under the control of an appointed receiver whose mandate was to maximize recovery for creditors. The remaining contracts were sold. The equipment was liquidated. The 147 employees were terminated. Leon filed a separate civil claim against Curtis alleging that the unauthorized signing of the LOI, without partnership approval, constituted a breach of fiduciary duty. Curtis argued he had implicit authority to sign preliminary documents as the partner responsible for sales and client relationships. The court found in favor of Leon on the fiduciary duty claim. The damages awarded were nominal. The company was already in receivership, and there were no meaningful assets remaining to recover. What this case turns on is not fraud. It is not theft. It is not malicious intent. It is a signature on a document that one partner believed was preliminary and non-binding, and that contained two clauses, an exclusivity provision and a cost recovery provision, that were neither. Three things that should have happened before that LOI was signed. 1. Joint review. Any document committing the partnership to exclusivity or financial obligation should have required both partners to review and approve before signing. The operating agreement should have mandated this explicitly. 2. Legal review. A business attorney reviewing the LOI would have identified the exclusivity clause and the cost recovery provision as binding and consequential within 30 minutes of reading it. 3. Negotiation of the exclusivity window. A 180-day exclusivity period is long. 60 to 90 days is standard in most LOI negotiations. The length of the window directly determined how trapped the company became when renegotiation began. None of these steps are complex. None require specialized knowledge to implement. They require the discipline to slow down before signing something that carries the company's name. One signature, 18 months. A company that took 6 years to build. In the next video, we look at a vendor fraud scheme that ran inside a mid-sized manufacturing company for 7 years, and what the annual audits missed every single time. This is verdict paper. Every collapse has a paper trail.